So good morning, everyone, and thank you very much for joining myself and Brendan for this webinar today. We hope you find it helpful and informative. So Brendan and I are going to be discussing the new restructuring process for small companies, which has recently been passed by the Dáil. It's known as the Small Company Administrative Rescue Process, or which is more commonly known as Scarp. And the legislation itself has not yet been officially commenced, but we expect it to be commenced imminently. Much recent newspaper commentary and indeed airtime has been devoted to the fact that the hospitality and retail sectors have been disproportionately affected by the pandemic restrictions. Interestingly, 78% of all small and micro companies in Ireland are quite staggeringly based in these sectors. And I suppose as government supports end in tandem with the easing restrictions, many people feel that such companies may feel a hangover effect. And companies in such position may indeed seek to avail of this new Scarp restructuring process. So during the next 50 minutes or so, we're going to give you a brief overview of the key Scarp provisions, followed then by a brief analysis of some of the important points to bear in mind. We'd of course welcome anyone to raise questions or make any questions during the course of the presentation. And you can do this by using the Zoom Q&A function. And we'll address these questions at the end of our presentation. So I'm firstly going to pass you to Brendan, who's going to discuss the reason for the introduction of the legislation. Brendan.
Thanks, Jill, and good morning, everybody. So why Scarp? We have a restructuring and insolvency regime in Ireland that is primarily limited to examinership and to a lesser extent formal and informal schemes of arrangement. If they don't work out or are unsuccessful, the options really are liquidation or at the behest of secured creditors receivership. The examinership process has been very successful in Ireland, but is primarily a process for larger companies. It's out of the reach of a lot of smaller entities due to costs. It just isn't, economically viable to spend somewhere in the region of a six-figure sum to restructure, and such as the low take-up by smaller and micro companies. To address this, government approached the CLRG, which is the Company Law Review Group, to examine and make recommendations for the formulation of a rescue process for small and micro companies. So it was to assist the companies starting post-pandemic to deal with unsustainable debt, to provide a quicker, more effective, cost-effective alternative to examinership with reduced court involvement. So in effect, an administrative rather than a court-driven solution. And Jill will comment on that point a little later on in the presentation. So a public consultation process commenced. So, business groups such as IBEC were consulted, financial institutions, government departments, and the professions such as the legal fraternity through the Law Society and accountants through CCABI. That process concluded in March 2021, after which CLRG made its recommendations to government. A bill was initially published in May of this year and took on board a lot of the recommendations made by CLRG. It went through both houses of the Oireachtas with some changes and was signed into law in July of this year. So all in all, for a piece of legislation to get through in 7 months was a very quick process, and showed, I suppose, the urgency by government to get a process in place to deal with companies exiting post-pandemic and having maybe warehouse debt and some unsustainable costs that they were unable to deal with going forward. As Jill referred to, the actual name of the Act is Companies Rescue Process for Small and Micro Companies Act 21. It's a bit of a mouthful, so I think we're all happy calling it Scarp rather than its full title. Commencement date of the Act, certainly before the end of the year. I was involved in a committee meeting with CCABI Insolvency last week, and the feedback is it will be by the end of the year. Certain court protocols and forms and so on are in the process of being prepared. It may be a little bit earlier, but that's where we're working to at the moment. I might then just ask Jill to give some sort of a compare and contrast in relation to the existing examinership process and the new Scarp process. So Jill, you might comment on that, please.
Yes,
thank you.
Thanks, Brendan. Yes, as Brendan mentioned, I'm just going to give an overview of, I suppose, some of the main comparisons between the examinership and Scarp. And I suppose in examinership, the requirement of court oversight led to complaints that the process was overly expensive and consequently has in practice resulted in only medium and large size enterprises availing of it. And what Scarp attempts to do is to mirror the positive aspects of examinership without the strict requirement for court applications in order to reduce the cost burden and make it really a more attractive restructuring option for small companies. So turning to just the first comparison I want to discuss, it's the administrative nature of Scarp. And broadly speaking, Scarp is designed to be an administrative process rather than a court-based process. And I suppose, what does this mean? While the appointment of an examiner requires an application to court by way of petition, the process advisor, who, as you know, is the equivalent to the examiner, can be appointed after a resolution is passed by the company directors. And similarly, then the rescue plan in Scarp takes effect after the creditors' meeting, obviously provided the relevant creditor approval thresholds are met, and we'll discuss those later on in the webinar. Following on then to my second comparison, which is linked to the administrative point, there's less court applications in Scarp. So, and I suppose this is probably the biggest selling point of the new process. And while it's possible that there may not be any court applications during the Scarp process, nevertheless, the legislation does set out the legal basis for certain court applications, which can be advanced by the process advisor or a creditor or another interested party. And I'm just going to give an overview of some of these applications. The first relates to automatic stay. While there's no automatic stay on creditor claims during the Scarp rescue process, there is a provision for the process advisor to make an application to court for a stay. And I suppose this is a very important point. The Scarp process doesn't prevent creditors from bringing proceedings against the company during the process. However, in the event a creditor, for example, seeks to enforce against the company or bring proceedings, a process advisor can bring an application before the court seeking a stay on creditor claims. And that's quite a big difference between the two processes. Another application that can be brought in Scarp is an application to repudiate onerous contracts, and I'm going to discuss this later on in the webinar. The process advisor can bring an application to seek directions from the court. The process advisor can bring an application to sell a secured asset. There's also an entitlement for a creditor to bring an application to object to the rescue plan. And then also a creditor can bring an application in respect of the costs and fees of the process advisor. The third comparison I want to touch on is the matter of length. So the process advisor must formulate the rescue plan and complete the creditors' meetings within 49 days of their appointment, which is quite a tight time period. There's then a 21-day cooling off period, after which the rescue plan is approved before it takes effect. So therefore, any rescue plan in Scarp takes effect within 70 days of the appointment of the process advisor. When you compare that to examinership, an examinership must usually be completed within 100 days. There is provision currently provided for 150 days under the emergency COVID-19 related legislation. This is due to expire at the end of December 2021. Another important comparison is the new concept of excludable debt. And the Scarp legislation envisages that certain revenue debts and debts owed to the Department of Social Welfare and Protection can be excluded from being written down. And these are termed excludable debts. This is not the case in examinership, where all debt is included. And Brendan is going to discuss this new concept later on. Another important difference is the creditors' meetings and the thresholds we met. The process for creditors' meetings set out in the new legislation is largely the same for creditors' meetings and examinerships. However, it's very important to note that a rescue plan in Scarp is deemed to have been accepted when 60% of the creditor class, which represents the majority in value of the claims in that class, have voted in favour of the resolution for the rescue plan. In examinership, a proposal is deemed to have been passed when a majority of creditors in number and value vote in favour of it. So the threshold is higher in Scarp, threshold to be met. A rescue plan then becomes binding on the company and creditors, where it's accepted by at least one class of impaired creditors meeting that threshold I've mentioned. 21 days has passed from the filing of the notice of approval with the Office of the relevant court, and then no objection has been filed. So then just the final comparison I want to mention is the effect of the failure of a rescue process in Scarp. In a High Court examinership, if the examinership fails and the scheme is not approved, then the company enters into liquidation. In Scarp, however, liquidation does not necessarily follow if the process fails. The process advisor is obliged to provide a report to the company if the process fails. And this report must include a recommendation as to whether the company should be wound up or not. And I suppose an important point to bear in mind that if a recommendation not to wind up is not followed by the directors and the company then becomes insolvent within the following 6 months, this factor may be considered by a court in any reckless trading applications against the directors. I suppose there's an example of some of the main comparisons that jumped out at me when I reviewed the legislation. And I'm now going to pass you back to Brendan, who's going to discuss the steps to commence the rescue process and enter into the rescue process. And also then he'll discuss the role of the process advisor. Brendan.
Thank you, Jill. In order for a company to avail of the process, they must be able to meet certain eligibility criteria and conditions. The slide in front of you there sets them out. I'm not going to go through them all one by one, but they relate to turnover, balance sheet, and employee numbers and values, and certain other conditions, one being that an examiner cannot have been appointed in the previous 5 years. So assuming that eligibility criteria is reached, the next step is for a company who are considering this process is to make full inquiry into the affairs of the company, prepare a statement of affairs of assets and liabilities, names and addresses of the creditors, and details of any security which they hold. This is done by way of a statutory declaration, so full inquiry has to be made by the directors in that regard. You might move on to the next slide there, thank you. Once that statement of affairs and details are provided, that has to be submitted to the process advisor, and I'll speak about that in a few moments, who will then determine whether the company has a reasonable prospect of survival, and that's set out under section 558C of the new Act. The PA will then, if we move on to the next slide, please, will review and issue a report to the directors, which will determine the reasonable prospect of survival and the reasons for his or her determination of that. That is done in writing. The PA will really get under the bonnet of the figures and the assertions made by the directors to be able to come to that conclusion. The PA's report will also have regard to various matters, including the eligibility of the company. Has it met the criteria that I've spoken about a few moments ago? The director's details and other directorships they may have, because that may also be of interest to creditors and so on at a later stage. An opinion as to whether or not the company has a reasonable prospect of survival, and the process will be more advantageous than a winding up for the company. So that goes back to the directors. The directors then consider what the PA report. They then convene a meeting and pass a resolution to commence the rescue process and appoint the process advisor. At this point, there's no requirements to make any application to court. As we said already, this is an administrative process. It's trying to cut down on court interaction. What is the process advisor? It is a new role, I suppose, in this Act. I suppose the best way of putting it is it is probably, in comparing it with examinership, it is the independent accountant and the examiner all rolled up into one. So it's effectively a dual role. The process advisor has to consider in the first instance that the company is eligible and suitable, and then it has to, they then have to go off and make and pull together a rescue plan to put to creditors and members in further down the road. The eligibility to act as a process advisor is the same as a liquidator or receiver under the Companies Act 2014. And for the purpose of their role as a process advisor, that person becomes an officer of the court. The main powers that a process advisor has is, and again, there's 4 or 5 I set down there. The last one is probably the most important for any accountant who's looking at becoming a process advisor, on the basis that if they enter into any contracts during the course of the rescue process, they may be personally liable for them unless the contract specifies otherwise. If we can move on to the next slide, please. So assuming an appointment has taken place, what is the role then of the process advisor? There's certain obligations to be carried out in short period of time, and they are within a 2-day period, a 5-day period, and as early as possible afterwards. So within the first 2 days, file with the CRO the notice of the process advisor's appointment, with the courts the resolution passed by the directors and the process advisor's determination and report, and a selection then of the jurisdiction for any court matters that occur during the course of the rescue process. And that's important in terms of costs and trying to keep costs to a minimum, whether it's High Court or Circuit Court. And I think Jill will refer to that a little bit more in her presentation as we go on. There's also a necessity to advertise in an irrecifical. So that all has to be done in the first 2 days. If we move on to the next slide, within 5 days, notification has to be given to interested parties, and interested parties are deemed to be employees, creditors and revenue, and the notice given to them has to contain the facts of appointment of a process examiner and advisor and the date of the resolution, details regarding any pre-appointment payments, any payments processed by the process advisor, and again dealing with the jurisdiction of court that will deal with the any matters that need to be litigated or go for direction. It's also an opportunity then for the process advisor to ask for details for creditors for the level of their debt, the nature of it, whether they hold any security and credit terms. So then as soon as practical, and we'll deal with excludable debts, and Jill has referred to it a few moments ago, the process examiner has to look at that, and any debts that are excludable, primarily state debt, have 14 days to object to be included in the rescue plan. So again, let's look at a process advisor being appointed, looking to prepare a rescue plan and deciding that it's not appropriate. So if that happens, he or she has to set out in writing why a rescue plan isn't feasible, and the next steps, which may include the recommendation to wind up that Jill referred to earlier, which isn't binding on the directors, but if subsequent insolvency takes place, there may be repercussions for those company directors. If it is a more positive outcome in terms of that the process advisor believes that a rescue plan is appropriate, he or she then go off and prepare their plan. It has to set out the various classes of creditors, list any classes of creditors or indeed shareholders who aren't impaired by the proposed plan, look to the management and direction and constitution of the company, and that may be bringing in different investors. It may be, new directors coming in, or people or shareholders stepping aside, and also looking then to provide details of a proposed implementation and timeline for those matters. Once the rescue plan is prepared, it has then to be issued to all creditors, and a meeting take place within 49 days. 7 days notice has to be given. So you're talking about 6 weeks from the date of appointment that a notice, including a rescue plan, a